So guys, please do bear with me. You guys know that I'm not a lawyer, and this is a very legal subject. But over my professional experience, I had the opportunity, for example, to negotiate a lot of software license agreements and to go through IP assessments for a lot of companies that I've helped over time. So I'll give a little bit of a theoretical approach to, and I'm going to share my screen right now, which is a better way to start. Um, I will give a more theoretical view of what IP means, particularly in Europe, because by the way, there's a substantial differences for you that work, for example, in software companies. There are substantial differences in terms of how you can protect your IP in software, particularly in Europe compared, for example, with the US. Okay, so this is catered to again an European view of the world of the IP world. Bear in mind that there is a little bit of difference when we're talking about the US, for example. Okay, and I'll try and also talk a little bit about those differences throughout the presentation. So let's start this one. So a few slides on some general information on IP subjects. Okay, so first of all, why does IP matter for a startup, for your startup? Basically, and if you remember the last the first training, um, in some situations, IP is just what you have. So when you go to an investor asking for money on pre-seed and seed rounds, for example, you only have a product. You only have your IP to show for, right? So we're in a knowledge economy today, right? And your intangible assets, your ideas, the code of a software, the brand, etc., are often just the only thing you have, the most valuable thing that you have to present for. Um, of course, if you protect your IP, it helps you differentiate from competitors and in the market. It helps protect some market share or gain market share faster, and of course support the building of a sustainable business, right? It's an investor appeal, right? It's most of the time, sometimes it's the only thing that you have to show for. It's what will drive, for example, in some situations, the difference between having a higher or a lower valuation on a round is having your IP protected, registered, right? A patent filed or copyright registered or a brand, a trademark registered also. Okay, and then if you have it protected, you can license it, you can sell the IP, and you can also try to enforce it over people that are using it, um, using or copying your IP. And of course, it helps with that, also helps mitigate some risks, which is basically preventing someone else to copy it or exploit what your ideas and your innovations. So let's dive a little bit deeper into the different types of protections that there are out there, particularly in Europe. So you can register your copyrights, a patent, trade secrets, trademarks, or in some situations for pure software companies, where particularly in Europe, where you cannot file a patent for just software. Sometimes register the design rights are also like detached from the copyright or the trademarks. It's also relevant. Okay, so what is copyright? Basically, copyright helps or basically protects the source code or the object code of a software. It protects the user interface. It protects data sets, databases, etc. Okay. And it, of course, protects all of the documentation, manuals, marketing materials, etc. Right? And this is applicable for software companies or for other companies, you can also protect for example, the description of your product, etc. Right? Um, it arises automatically in Europe. So the moment that you write something, it automatically becomes your copyright. Now, on software, you need to be careful with this because it's not only writing it on the computer, right? You have to actually put it in a tangible, hard, um, hard carrier, like a disk or a CD, a DVD, whatever, right? A hard disk, right? It doesn't really having it in the cloud. It's not doesn't help you protect it. Okay. Um, Basically, it lasts forever or for as long as the creator is lives. So when particularly when you're talking about, for example, a book, okay, and through all the life of the author plus 70 years. So there's when you're talking about, for example, music, right, and you hear that, okay, the I don't know, the family of Michael Jackson, they will be receiving royalties on the music that Michael Jackson produced and created for 70 years after its death. Okay. So they will be wealthy for many, 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 many years. Okay. Um, and it doesn't protect underlying ideas, algorithms, functionalities, business methods. Okay. So even in software, it doesn't. It protects the code, but it doesn't protect what the software actually does. Okay, if you understand what I mean. Okay, so e- imagine so and a great example of that is for example, the ERP software, right? So there's the number of ERP softwares that do exactly the same thing, and I'm talking about my own area, the finance. I know a bunch of ERPs. You have Oracle, you have Sage, you have SAP, etc. And all of those softwares have different source codes which are protected by copyright, but the functionality is not protected. So you can have different source codes that are protected by copyright, they cannot use the same source code, but they can do exactly the same thing in the end and have the same function. Okay, so that's an example. Okay, any questions so far? So patents. Let's talk a little bit about patents. And I have there in small letters on the title with the European nuances. Again, as I said, for example, for software, it's very, very different to be in Europe or to be in the US. Okay. So a patent protects technical inventions, new, inventive, and industrially applicable solutions to technical problems. Okay. Um, I can tell you that, for example, and the girls will laugh, but the first bra was actually patented. Okay, it was a triangle thing with some straps. Okay, so and it was patented and it was exclusive for the person that patented it for 20 years. Okay, so nowadays, of course, a bra is a bra, right? But back then, in like the 1940s, 50s, you can search in the internet and you can find it very easily. It was just one person building, basically producing bras. Um, so it can also protect computer implemented inventions. Okay, this is where, again, for software, it gets a little bit tricky. Okay. In Europe, programs for computers as such are excluded from patentability. So you cannot patent software per se, but what you can patent is and there's the examples there for Europe, which is what you can patent is the software together with something that is a novelty. Okay, so if you improve data processing, if you improve, for example, um, when you're talking about cloud, you include you improve the latency, reduce the latency, or etc. You can actually patent, but you can patent the software with that particular thing. Okay. Um, for example, but you cannot just simply patent algorithms or things like that just per se. Okay, this is very tricky to explain. Okay, so I remember one example where someone developed a piece of code that it actually optimized the load balancing on a multi-core processor, right? And so and that piece of software, together with the components of the hardware, which is the multi-core processor, was possible to patent, right? Because it was solving a technical issue, which was how to optimize and reduce latencies and the let's say the inefficiencies of the use of the multi-core processor. Okay. Did I make myself clear, or am I being too blubby? This is very particular. Okay. But yeah. So in a nutshell, you cannot in Europe, for example, in the US you can. In the US, you have an algorithm that does something. You can patent the algorithm. Okay, but it's only basically exclusive for you to use in the US. You can. It's not exclusive for you to use in Europe. Okay. But if it solves a technical issue, a technical problem, and interacts with hardware, with the physical thing, it actually can be also patented in Europe. So there's a very thin line between what can and cannot be, but it's and it's difficult to navigate this. Okay. So it is it is but if you patent something and it's the patent is granted, it is valid and you have exclusive rights of usage of that patent knowledge for 20 years. It does require of up to 20 years. It does require renewal fees. If you don't pay the renewal fees, it will expire. Okay. It is from the filing date and not from the granting date. For you to have an idea, between filing dates and granting dates, it can go anywhere between 18 to 24 months. Okay, if there's, for example, people that contests or that has that basically goes to court saying that that patent is not possible to be registered. One thing that is not here, and it is important. It is geographically restrained. I just mentioned for the algorithms, for example, that it's patented in the US, but it's only exclusive to you in the US because it is geographically restrained. Okay, so if you file a patent in Portugal, for example, or in Ireland or in Greece, if you don't expand the geographical range of the patent, if you don't do if you I forgot the name, um, if you don't, for example, go to the European Patent Office and make it European wide, right? You're only allowed to your exclusive rights only applicable within, let's say, the country where you first register it, and you start in your own country or in one country. You don't go Europe wide from the start. You need to start in a specific country, like for example, which is a little bit different from for a trade compared to a trademark, for example. Okay. Um, it is a very time consuming and very expensive process, but it can be very fruitful and also, of course, very valuable to have a patent if you can actually get it. Um, and one important thing is it requires disclosure. So the moment that it's granted, it is published and everyone knows what you're doing. Okay, so this is very, very important also. Um, so you can have IP, which is not actual IP, which is not published, right? Like the copyright or the trademark or the patent. You can have IP, which is your trade secret. Basically, it's basically confidential information that you keep for yourself, right? Um, Proprietary algorithms, unpatentable processes, particularly in Europe, unique development methodologies, customer lists, pricing strategies, etc. All of this is IP. It's intellectual property or or general confidential information. Okay. Um, so there is a directive that talks about trade secrets in Europe. Okay. And it refers to something that is not generally known or easily acceptable. It has commercial value, and people did uh, do some reasonable steps to maintain it as a secret, right? For example, have signed NDAs with their suppliers, with their customers, with their confidentiality clauses on their employment agreements with their collaborators, etc. Right? Um, a trade secret doesn't have a lifetime or a lifespan. It can be perpetual. It can be forever, as long as it remains secret, right? Um, so, but of course, there's no protection against independent discovery or reverse engineering, right? Once disclosed, it's lost. It's no longer a trade secret, and also it doesn't protect any from for example, compared to a patent where it's like first inventor priority, right? So independently of someone else re- being doing research on something, the moment that someone files for a patent, right? It's technically or typically it's called the priority date. You get the priority date, right? If someone else is in the meantime discloses a product or tries to file for a patent in that is similar or that is similar to what you just submitted, uh, basically that will be rejected. And if it's granted, you can actually go go to court with the entity that started, promoting a product that is similar to your patent, and ask them to stop or to pay for royalties to you because you have a patent, right? In the case of a trade secret, there's no protection like that, right? It's like there's no protected IP. Okay. So in some cases it's valuable, but it's weaker. It's a weaker protection. Um, You can also register for a trademark. Register a trademark, basically everything that distinguishes your company from others, your name, your logo, uh, the an icon, a particular button or on your software, etc. You can do whatever, right? So the for example, the um, for some time the emojis were trademarked by Microsoft when they launched the Messenger like 20 years or 25 years ago, right? Um, you know, but you can also trademark uh, sounds, jingles, even smells, right? Um, just for you to have an idea, one of the most known uh, sound or jingle trademarks is the little um, that little jingle of Intel that appeared on the at the end of the for example the HP commercials when they said Intel Inside. The Intel Inside that then jingle was trademarked by Intel. Okay. Um, and the other thing is you can have trademarks which are which are basically the same in terms of spelling, but for different products. So a trademark is registered on like there's a list of 46 different products and services where you have to choose what's the product or service you're trademarking for, and you can have the same trademark for different products. One very good example is Dove. So Dove. Does anyone know um, how many Dove trademarks there is for different or the most known? Dove. Does anyone? Anyone wants to guess? If, did anyone ever heard about the Dove, the chocolate or the ice cream?
Yes, the chocolate and the soap as well,
And the
no?
Dove. They are different trademarks from different companies. Correct, Lina? Right? Okay, so Dove chocolate is from one uh, or ice cream is from one company, um, and Dove the soap for you to wash is from another company. Okay. um, Again, it is also geographically restrained. So if you register a trademark in Spain, it is not enforceable in Portugal unless you register for an European trademark, which is then enforceable within the 27 um, countries that are attached to the European Patent Office, but it's not enforceable in the US. Okay, for example. Okay. It has a 10-year duration, and but it can be renewed indefinitely. So you register initially for 10 years, you pay the fee for 10 years, different from, for example, a patent where you pay basically a renewable fee every single year. But then if you want to renew it, 10 years later you pay again, you have another 10 years. And it's so on and so on and so on. Okay. Um, any other questions before I go to the last one? Any questions before I go to the last one? Nope. Okay. So design right, it's close to it's close to a copyright. It protects basically the appearance of the product, shape, configuration, pattern, etc. In software, for example, the relevance is for unique app icons, distinctive user interface layouts, etc. Um, in Europe, there's two types of design rights. One which is unregistered, community design because it gets an automatic protection for 3 years from first disclosure. And then there's a registered, which extends it to up to 25 years with 5-year intervals of renewal. Yeah. So basically, this is for someone that has a very unique user interface or a very unique design on their website, etc. You can actually register and have it protected for some years. Okay, with a smaller fee than a patent, and but also with a less protective. Okay, it's an add-on to the basically to the copyright. Okay. Any questions so far? Next, I'm going to go into some examples of software license agreements and how yes, Maria.
Thank you. I don't know if you hear me well because I have a lot of
I'm good.
background noise. Okay. My question has to do with the replications because, as you understand, at this stage of our solutions, we are like in the demo phase. We try to demonstrate them and, of course, replicate them to see their potential for commercialization. So part of the replication is to replicate the solution with other companies, not just demo sites, operational, implementation, but we opt for a co-development in components of the solution that we need to optimize. So regarding this part, during a replication agreement, in an replication agreement, could we try to outline the possibilities for the co-development and how to align the IPs if eventually the replicator proves an optimization of a component of the solution? And how can this be justified just from one demonstration? Is it enough? Because we are into this phase of our solution, we know we are missing one part, a component, to offer the complete service. And there is another company that offers to replicate our solution, add its own service, and test if the solution is viable.
Okay, so let me see if I understood. So there's a few things there, right? So one important thing is if you're in what status is your IP in terms of protection, right? Do you have a patent? Do you have provisional?
TRL 7 stage.
Yeah, the level of development doesn't really matter when we're talking about protection, right? What matters is it a trade secret? Do you file for a patent or at least a provisional patent, right? Or so what's the status of your background IP, right? When you're going to do a partnership agreement with someone, right? What's the status? Is it protected or not, right? Because it will have different implications in terms of let's say monetization afterwards, right? Now, if you have, for example, a patent or a provisional patent submitted, and you're going to go for a partnership agreement with that, right, as the background IP, if there's a it all depends on what's on the agreement, but if there's any development on top of that, it can generate new protectable IP, right? Because if it's a completely different solution, right? Or if it's an incremental solution, right? You can do incremental protection or incremental patent, right? And then it's a matter of determining how much of the, let's say, of the proceeds of the commercial value will be distributed between between the two parties in the agreement, or the different parties in the agreement, which is the trickiest thing, because there's no, let's say, recipe to do that, right? It always depends on how much increment it was, right? If it's something that is a completely new thing, then most of the times the background is irrelevant for the use. If it's just a small increment, of course, the background is then more relevant. There's always negotiation involved in that, and, let's say, very subjective assessment, right? But the first step is to understand what's the status of the background IP and describe it well in the agreement. Okay? Makes
Yeah,
sense?
of
Did I
course,
understand?
yeah, it makes sense. Yes.
Okay. So any other questions for now, or shall I move on?
Second question, can I raise the second one? So, is it a good practice when you communicate for such matters to begin your message like with the sentence that the information shared is confidential and please treat accordingly?
So
Is this safe as a practice when you communicate it through emails?
So one thing that is important, first of all, to write on an email that is confidential doesn't replace, for example, having an NDA. Okay, it's a weaker protection, right? But yeah, so in every presentation that you're sharing confidential information, every time I'm going to, for example, to do a pitch to an investor with, or helping someone do a pitch on an investment, the first thing that comes on the first slide is, this is confidential information, don't record it, blah, 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 blah. Okay. But it doesn't replace having actually a paper signed by the person, okay, or by the entity that you're dealing with, okay. Internal emails to the organization, they are always deemed confidential, but there's also different levels of confidentiality, so that you can have in your own internal policies, okay, and that can be more or less restrictive in terms of use, right? Okay, so again, yes, you should have all of those disclaimers either on the subject or on the footnote of the email, right? On the footer of the email, but it has a weaker protection than having a confidentiality agreement, a non-disclosure agreement. Okay.
Thank you.
So now I'm going to talk a little bit about, so we talked a little bit about the different ways of protecting your IP. So let's now talk a little about how to monetize it and the different types of agreements that can have, particularly a little bit about software licensing agreement or licensing agreements in general. Okay. So a software license agreement is basically it's a contract between the owner of the software and the user. Okay. It basically specifies the how the user can actually use the software, and basically restricts the what it can do with the software in terms of transfer, etc. It doesn't transfer ownership, so you're not, by signing a software licensing agreement, you're not transferring the ownership of the source code or the ownership of the copyright to the user. Okay. It actually, as I said, it defines what the user can do with the software, what's the software is going to be used for, and what's the function it's going to be doing. Okay. why it's essential to sign a license agreement? It's basically it helps you maintain control over your IP and who is using it and for what. It basically defines how you're gonna price it and how you're gonna monetize it. It mitigates risk because it basically has then some legal clauses on limits of liability, disclaim warranties, support, etc. Let me put it this way: I've over time, particularly when I was at Feeds, which was a very big software company that I worked for. Most of the discussions on software licensing agreements that I had with um, with clients was one, it was on the use, so on the scope of the license. When you're talking about, for example, a financial institution or a bank that have different business lines, one of the discussion which was attached to the pricing was also what were the business lines or the use that the scope of the license. But then the biggest discussions came with limits of liability, warranties, and the support schedule of the software. And it is very important because, for example, if something goes wrong or if your software has some adverse reaction with your client systems and provokes losses to it, to have limitation of liability, which also will then, in most situations, determine the size of or the limits of the insurance that you're going to have to do, civil insurances, etc. It can save a software, a small startup, from going bankrupt if something goes wrong. Okay. And of course, it helps also the users to adhere to its terms. Some key components. So grant of license, as I said, scope of use. This was a very big area of discussion when I was negotiating software licensing agreements. The restrictions on use, no reverse engineering, no distribution, no supplying your source code, etc., 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 which is very, very important, and people cannot actually, and preventing your clients from accessing your source code. The term and duration, pay fees and payment terms, warranty disclaimers and limitation of liability, termination clauses, and governing law. Okay. It is important when you're talking about startups, what is the country where that goes, or what is the country which governing law will rule the contract, right? Because if you most of the times the clients want the governing law to be in their country, but if we're talking about a small company, I don't know, in Albania, dealing with a UK big corp, right, or a German big corp, if there's some legal recourse that comes out of the contract for a small company in Albania to be defending themselves in the home court of the client, for example, in Germany, not only it becomes very expensive, but it's also very, very hard for it to defend. So most of the times, what I used to do is to put it on a neutral ground, like you know, Belgium, or well, if the client was outside of the UK, I would put it in the UK, or but the what I actually preferred it to is to have it in my home courts. So in the home courts of the supplier of the licensee, of the licensor. So types of software licenses. So there are the proprietary licenses. So this is basically the most common type of licenses for commercial software. They restrict what the user's rights are, what they can do, etc. Right. So it's the most protective type of license of software license that exists. Compared to and are the most common ones, basically EULAs that I'm pretty sure you have all signed, even personally, and you know about software as a service agreements, subscription licensing agreements, perpetual licenses, or enterprise licenses. So the main advantage for startups are basically the maximum control over your IP, clear monetization pathways, and strong legal recourse against unauthorized use. Okay, of course, legal recourses are expensive, but sometimes it's what saves a startup if someone starts using against its right their software. This is on the opposite side, we have the open source licenses, that have basically grants the users access to the source code, and it can use it and modify it and distribute it as they wish. Okay. The key philosophy here, of course, is collaboration, transparency, and be a community-driven development. And there are two different types of licenses, the permissive versus and the copyleft. So the permissive licenses, and some examples are there, MIT, Apache 2.0, BSD basically allows users to do almost anything with the code, including integrating them into proprietary software, and not share their modifications, the modifications that they did to the source code. And then there's the copyleft licenses, some examples, GPL, LGPL, AGPL, which is a little bit more restrictive. And if you use it, you may be required to make your entire software or parts of it available under the same copyleft license. By the way, one of the things that we always had to do when we're going through. So, for example, Feeds, I had the proprietary software license. Okay, but of course, we used. So part of our source code was made of permissive licenses, open source software. Okay, and one thing that we had to do always was to basically, particularly libraries and things like that. And one thing that we had to do was to disclose which open source licenses we were using, not only on the software licensing agreements, but particularly when we were going through due diligences for investment rounds. Okay, which is something that investors do care about. This, although you saying that you have a proprietary software, everyone knows that parts of it are composed by open source software, and people want to know how much and if it can actually, and if you have, for example, some licenses there that might be exposing your proprietary software to the public. Okay. And that, of course, will reduce the value of your proprietary license. So when choosing your licensing strategy, you have to understand, you basically need to look at your business model to try and understand what kind of software license you're going to be doing, SaaS or subscription, on-premise, etc. You have to understand what your technology stack, as I was just saying, how heavily are you relying on open source, even if you have a proprietary software? What's your target market? What's your future goals? Do you plan to sell the company? Do you plan to just be a standalone company, etc.? There's no single solution. Most of the times there's a mix between different types of software licenses being used, and there's also and it's very, very common, as I said, to have proprietary software, which is populated by in parts of it by open source. One thing very, very relevant is having legal advice supporting you or legal counsel supporting you when developing your licensing agreements can prevent a lot of hassle in the future. So just some considerations for on this. Basically, you need to have an holistic IP strategy. Integrate licensing with your protection strategy. Timing is key. Registering the IP or doing the licensing agreements before product launch and determining how it's going to work. It's very, very important. Um, employee agreements are crucial. So make sure that there's a clause for IP assigning and of course and not confidentiality on your employees' contracts. Be careful with open source. Often, particularly because, well, development teams are creative. So be careful or do regular open source software audits to your source code. Be aware of and make sure that no viral licenses can compromise that or are included on your source code. Do a continuous monitoring of the landscape of your environment of your market to understand if there's no IP infringement, and of course one thing important is the jurisdiction and the governing law of the licensing agreements. I will potentially skip this, and this will be on the presentation because I've already mentioned most of this. So before I go into some case studies, and we have 5 minutes, I don't know if we're going to have time to go through all of them. I will just open the floor to some more questions from you guys. No? No questions? Okay, I have just a few case studies. I'll go very fast through some of them. So this is a copyright versus software case study. This was basically one case that happened particularly in the US, but it's illustrative of some issues with copyrights. And so it basically put Oracle versus Google, so two very big, well-known giants. So when Oracle acquired Sun Microsystems, it sued Google for basically Google infringement on the use of Java, the Java APIs. Okay, so you can read it. Basically, Oracle claimed that Google copied the declarations, the names, etc., of all of their the Java APIs from Sun Microsystems, even if the implementation code was slightly different. Okay. So some outcome and lessons. So after a long and complex legal battle, which spanned over a decade, the US Supreme Court ultimately ruled in favor of Google, stating that Google's use of Java APIs constituted fair use. So basically, the Sun Microsystems didn't do any patent on their Java APIs and their Java API packages, and Google basically simply integrated it with with uh, with their systems, with not changing the software itself and not putting in jeopardy the copyright of Sun Microsystems, but basically they use it. Okay, so basically it became almost public knowledge as long as it's referred that it's not your copyright, it's someone else's copyright. So a little bit of more of an European case. So Sony versus Datel. So Sony sued Datel, a German company in Germany, over cheating software for PlayStation consoles. Okay. So the Sony claimed copyright infringement as Datel's products allowed users to alter aspects of their games. So the Court of Justice of the European Union ultimately ruled that modifying temporary variables in the game's RAM without altering the source code does not constitute copyright infringement under the EU Software Directive. So basically, which means that Datel won versus Sony. Okay, so it clarifies that. So in this example, it clarifies that copyright protection for software in Europe is primarily limited to the expression of the program, source code, and does not extend to the data generated or modified during the program's execution. Okay, as I said, so it's a very weak protection. Okay, unfortunately, in Europe, it is what it is. So one case of patents and software. So this case concerned the patentability of an artificial neural network. This is a very recent case in the UK that an invention that aimed to recommend music based on emotional perception. The core question was whether the artificial neural network as a computer program was excluded for patentability under UK and by extension European law because it lacked a technical effect. The High Court initially found it patentable, but the Court of Appeal overturned. So some lessons here. The UK Court of Appeal held that an artificial neural network is a computer, and the weights biases from AI training are computer programs. It ruled that the invention fell within the computer program as such, exclusion because it didn't provide a further technical effect beyond the typical operation of a computer program. This case reinforces the strict technical effect requirement for software patents in Europe. Purely algorithmic or business method inventions, even if sophisticated AI, are unlikely to be patentable. Okay. So we're just a few more things, and because we're basically wrapping up in terms of time, there's been over time very big battles between Apple, Samsung, Ericsson, etc. Over smartphone patents. Okay, there was a series of global lawsuits, particularly prominent between Apple and Samsung over various design and utility patents related to smartphone features. So the allegations of copying features, designs, and infringing fundamental technologies, mixed results with some significant damages awarded and some features redesigned. The Unified Patent Court recently launched in Europe. This is designed to streamline these cross-border patent disputes. Okay. By the way, Apple and Samsung, they've been in court for example, Apple accusing Samsung for copying the iPhone design or the camera design or whatever. Sometimes Samsung wins, sometimes Apple wins. Apple also put in court Xiaomi, etc., or Huawei also for copying the design of the iPhone, and Samsung also for some of the Huawei's phones. By the way, trying to go to court with a Chinese company, it's like you can forget it. It's the most difficult thing in the world. Okay, but China is the only country in the world or that doesn't actually respect patent and things like that. Okay. I'm so I'll give this to you guys. It has a couple more use cases, one on trade secrets, another one on trademarks. This one is particularly interesting because I actually didn't know about Tom Brown, but it has a logo which is relatively similar to Adidas, but actually Adidas actually lost against them in court for trademark infringement, or in this case confundability. But they were arguing that it could confuse the consumers. So just some conclusions. I particularly like that sentence up there. Your IP is your future. Okay. Some key takeaways then: protect what matters. Combine copyright, patents, trade secrets, and trademarks. Remember that specifics, the European Edge specifics, technical effect for patents in the software world, particularly. Be proactive, not reactive. Patents, the sooner you get a patent, even if it's a provisional patent, and for the last 20-25 years, you're able to submit provisional patents, which gives you a priority date, even if you don't have a full patent already written and ready to be submitted. But at least it gives you a priority date and gives you the possibility of acting against someone that is trying to do something similar to what you're doing. Keep controls through contracts. Be aware of proprietary software versus open software for you guys that have software companies, and do tailor your agreements to your needs, whatever type of agreements, licensing agreements that you have. Do assess your IP status, develop a strategy and if you're building a business plan or a pitch, an IP strategy slide or an IP strategy section on your business plan, it's important. And do seek expert counsel. So this is, as I said, I'm not a lawyer, but having an IP lawyer, IP attorney with you that can help you navigate this treacherous world, it's important. We are 5 minutes over time. I don't know if anyone else has any other questions.
I don't think so. If anyone wants, they can always write back to the email that we'll be sending to the ones that participated and enrolled in the session. So thank you so much, Philip, for your participation. Here it's Lina Silveira from F6S, project manager from Remedies project. And we'd like to thank you also for your participation, and especially for Philip for sharing his knowledge. So I will stop recording now.